The morning my daughter-in-law had me declared mentally incompetent, I was sitting at my kitchen table drinking coffee and reading the sports section of the Houston Chronicle. That's how ordinary it was. That's how little warning I had. The knock came around 9. Not the door, actually. My phone. My son, Lester, calling from what I thought was a routine Tuesday at his office. Instead, I heard the voice of a woman I had never trusted. My daughter-in-law, Serena, using Lester's phone, which already told me everything I needed to know. "We just want what's best for you," she said. "Lester and I have been talking to a specialist." I told her I felt fine. "That's what concerns us," she said, and then she hung up. I sat there for a long moment looking at the coffee steam rising off my mug. Outside, the neighborhood was quiet. A mockingbird was going through its whole repertoire in the pecan tree by the fence. I'd lived in this house for 31 years. Paid it off in 2009. Raised Lester in the bedroom down the hall, the one he used to cover in Houston Rockets posters until his mother made him take them down. She passed 9 years ago. Pancreatic cancer. 3 months from diagnosis to the end. After that, it was just me and the house and the work I'd spent 4 decades building. I want to explain what I did for a living because it matters to the story. For 38 years, I worked as a forensic accountant. Not glamorous. Nobody makes movies about forensic accountants. But the FBI called us in on fraud cases. Corporate embezzlement, insurance schemes, estate manipulation. That was my world. I retired at 64 with a reputation in this state that I am not too modest to call solid. I consulted for 2 more years after that, then stopped completely at 66 because my knees hurt and I'd earned the right to sit on my porch and watch the neighbor's cat walk along the fence rail. I was 68 when Lester married Serena. She came into our lives quickly and arranged herself inside them even quicker. Within 6 months, she had Lester's finances consolidated into a joint account I never quite understood the structure of. Within a year, she had convinced him to leave his engineering firm and join her brother's real estate company. Within 18 months, she had started calling me Dad, in a tone that made the word feel like a transaction. I didn't say much. I want to be clear about that. I've always believed that children need to find their own way, and that fathers who meddle in marriages do more damage than the problems they think they're solving. So I watched, and I stayed quiet, and I hosted Christmas and grilled steaks on the 4th of July, and tried to be the kind of father-in-law who doesn't cause trouble. That patience cost me nearly everything. The legal papers arrived on a Thursday morning in February. A process server, which I found insulting, as though I would refuse to accept documents, as though I were the kind of man who hides from what he's owed. The filing was a petition for guardianship. Serena and Lester were asking the court to appoint them as my legal guardians on the grounds that I was suffering from cognitive decline and diminished capacity to manage personal affairs. I read the whole thing at the kitchen table with my second cup of coffee. The petition cited 3 incidents. First, I had apparently expressed confusion regarding financial matters during a Thanksgiving dinner conversation. What had actually happened was that I'd corrected Serena's brother on the tax implications of a 1031 exchange, and he hadn't liked it. Second, I had failed to maintain the property. Based on the fact that I'd had a roofer out 3 times over the summer because they kept doing shoddy work, and Serena had interpreted my complaints about the roofer as evidence I couldn't manage my own home. Third, I had become socially withdrawn and exhibited signs of paranoia, which, as best I could reconstruct, meant that I had declined to attend her company's holiday party and had once asked Lester why he needed my account number to update the family contact information, for some reason I never quite followed. Attached to the petition was a letter from a Dr. Whitmore, a psychiatrist I had never met, who stated that based on a review of collateral reports from family members, he had concerns about my cognitive status and recommended a formal evaluation. A psychiatrist who had never examined me, offering an opinion based on what my daughter-in-law told him. I set the papers down. I looked out the window. The mockingbird was back. I called my attorney, a woman named Judith who had handled my estate planning and who I had known for 20 years. I told her what had arrived. She was quiet for a moment, and then she said, "How soon can you be here?" What Lester and Serena did not know, what they could not have known because I had never discussed it with anyone outside of Judith's office, was that 18 months earlier, I had updated my estate documents in a way that reflected certain concerns I had begun to develop about the direction of things. My house, my investment accounts, my pension, and the proceeds of a life insurance policy I'd carried since 1987. None of it was structured the way they assumed. I had placed my primary assets into a revocable living trust administered by a corporate trustee at a bank in Austin. My named beneficiaries were three: my sister Dorothy in Albuquerque, the endowment fund of the university where I taught a forensic accounting seminar for 12 years, and a small animal rescue organization that my late wife had volunteered with every Saturday for 11 years until she got sick. Lester was not in the trust. I had not told him this. I had intended to, eventually, in the right conversation at the right moment, but the right moment had never come. And then the guardianship petition arrived, and I understood that the right moment was never going to come, and that this was what it had always been moving toward. I want to say something about Lester here, because I have spent a great deal of time trying to be fair to him in my own mind. I do not think my son is a bad man. I think he fell in love with a woman who was persuasive and organized, and who saw in him a kind of gentle compliance that she could work with. I think he told himself that the guardianship petition was the right thing to do, that it was concerned for me, that his wife wouldn't suggest something genuinely harmful. I think he believed that right up until the hearing. The court date was set for a Tuesday in April. Before that, I was required to undergo an independent psychological evaluation ordered by the court, not the review from Dr. Kess Whitmore, who Judith immediately and surgically dismantled in her response filing by pointing out that he had never met me, that his letter did not meet the evidentiary standard for a competency determination, and that his practice had 3 pending complaints with the state medical board. The court appointed its own evaluator, a Dr. Okafor at a clinic in downtown Houston. I spent 4 hours with Dr. Okafor on a Friday afternoon in March. She was thorough. She was not unkind. She gave me cognitive assessments, asked me about my work history, asked me to walk her through my financial structures, asked me how I spent my time, asked me about my relationships. At the end, she asked me if I knew why I was there. I told her yes. My daughter-in-law wanted to control my assets and had found a route she thought would work. Dr. Okafor looked at me for a moment without writing anything down. Then she wrote something down. Her report, submitted to the court 3 weeks later, found no evidence of cognitive decline. It noted that my recall of dates, financial structures, and procedural details was exceptional, that I demonstrated clear and organized executive reasoning, and that I showed no indicators of paranoia or social withdrawal that would be clinically significant. She recommended the petition be dismissed. Serena's attorney filed an objection and requested a second evaluation. The judge denied it. The hearing itself lasted most of the morning. I sat at the respondent's table with Judith, who had spent 30 years in family law, and who wore the same expression throughout: calm, specific, slightly bored, the way good attorneys look when they know they've already won and are just waiting for the other side to figure it out. Serena and Lester sat at the petitioner's table with their attorney, a man named Gould who I recognized from a case I'd consulted on years ago. He was competent. He wasn't going to save them. What happened in that courtroom I will try to describe as fairly as I can, because I've replayed it many times, and I want to be honest about what it cost, even on the side that won. Gould led with the 3 incidents from the petition: the roofer situation, the holiday party, the Thanksgiving conversation. Judith cross-examined Serena for 40 minutes. She established, document by document, that I had a written record of every dispute with the roofing contractor, including emails, inspection reports, and a final settlement letter, not evidence of confusion, but of methodical documentation. She introduced a text message Serena had sent to her brother 3 days after Thanksgiving that said, quote, "He embarrassed Owen in front of everyone, and Owen is still furious." That was the cognitive decline incident. A retired forensic accountant had corrected someone's tax analysis at the dinner table, and they hadn't liked it. Then Judith called me to the stand. I testified for about an hour. I walked the court through my career, my estate planning, the structure of my trust, the timeline of changes I had made and why I had made them. I was specific about dates. I cited documents by exhibit number. At one point, the judge asked me to explain what a 1031 exchange was, and I explained it, and he nodded slowly. Then Judith asked me the question she had prepared me for. In your professional experience as a forensic accountant, she said, what does a guardianship petition targeting a mentally competent individual typically indicate? Gould objected on relevance. The judge overruled him. In my experience, I said, it's almost always about assets. Someone expects to inherit, discovers they may not, and looks for a legal mechanism to gain control before the estate settles naturally. The guardianship route is attractive because if it succeeds, the guardian gains full control of financial decisions. What the petitioners here may not have known is that my assets are held in trust with a corporate trustee. A guardianship order would have given them authority over my personal spending, my grocery budget, my medical appointments. It would not have given them access to the trust, the investment accounts, or the real estate, because those assets are no longer in my name. The room was quiet. They would have won control, I said, of very little. Lester was staring at the table. I watched his face in the moment he understood what I had just said. I had not told him about the trust. He had not known, and now he was learning it here, in a courtroom, in front of a judge, while his wife sat next to him, having just spent what I later calculated was approximately $40,000 in legal fees pursuing an asset she did not have. The petition was dismissed that afternoon. The judge made several remarks from the bench that I will not quote at length, but that addressed, pointedly, the use of guardianship proceedings as financial instruments against competent adults. Serena and Lester did not speak to me after the hearing. They walked past me in the corridor without stopping. I noticed that she walked slightly ahead of him. I drove home and sat on the porch for a long time. The neighbor's cat was on the fence. The mockingbird was somewhere in the pecan tree, though I couldn't see it. That was 14 months ago. In the time since, Lester has called me twice. Both were short conversations. In the first, he told me he was sorry, in a way that was true, but also insufficient. And I told him I heard him and that I needed time. In the second, he asked if we could have dinner. I said yes, but we haven't scheduled it yet. I'm not withholding that dinner to punish him. I'm waiting until I trust that it won't hurt more than it helps. That day may come sooner than I expect, or it may take longer. I am 69 years old, and I've learned that some things cannot be rushed without breaking. Serena, I have not spoken to. I don't anticipate that changing. What I think about now, when I think about this whole episode, and I think about it less than I expected, which is maybe the most surprising part, is the morning the papers arrived. How ordinary it was. How I was just sitting there with my coffee and the sports section. How the whole structure of what she'd been building had been assembling itself somewhere outside my sight, and I'd had no idea. And then one Thursday morning it arrived at my door and I read it and I called Judith. And nothing they had built could touch what I had built. People ask me sometimes, usually when I tell a version of this story at my forensic accounting seminar. I went back to teaching part-time one semester a year because it turns out I missed it. They asked me what I would say to someone in a similar situation, older, with assets, with family they're not sure about. I tell them the same thing I tell my students about evidence: document everything, structure your affairs correctly, and never assume that because something hasn't happened yet, it can't happen to you. The threat doesn't announce itself. It sits at your Thanksgiving table and calls you Dad and waits. And then one Thursday morning, it knocks. The thing about consequences is that they don't announce themselves. They accumulate quietly in the choices people make when they think no one is paying attention, and then one day they arrive all at once and there's nowhere left to stand. Serena believed she was dealing with a retired old man whose best years were behind him. That assumption was the foundation of everything she built, and it was wrong from the first stone. She had watched me sit on my porch. She had watched me read the paper and tend the yard and go to bed early. She had decided that what she saw was all there was. That's not a character flaw that's unique to her. It's the most common mistake people make about anyone who's lived long enough to have learned patience. They confuse stillness with emptiness. What I keep coming back to is this. The 38 years I spent in forensic accounting were not wasted on her scheme. Every document she filed, I could read with the same eye I'd trained on corporate fraud cases in the 1990s. Every procedural move her attorney made, I recognized. I had seen variations of this maneuver before, not between family members but in boardrooms and courtrooms, and the mechanics are the same regardless of who's sitting at the table. The competence she was trying to strip away from me in court was the very thing that dismantled her case. That's not luck. That's what happens when a person spends a lifetime building real skill instead of performing it. But I don't want to give the impression that this was easy or that I felt nothing. There were nights between the filing and the hearing when I sat in the same kitchen where I raised my son and felt something I can only describe as a grief that had nowhere clean to land. Not anger at Serena. That was there, but it was manageable. Grief for Lester. For the version of my son I thought I knew. For the realization that somewhere along the way, in ways I probably contributed to without understanding how, he had become a man who would sign his name to a document accusing his father of losing his mind. Integrity is not something you perform for other people. It's the private standard you hold yourself to when no one is looking and there's no reward for doing the right thing. I had structured my estate honestly, updated it through legitimate channels, documented every decision. I had done that years before any of this happened, not to protect myself from Lester and Serena specifically, but because it was the correct thing to do. That habit, the habit of doing things correctly, whether or not it's convenient, was ultimately the only thing that protected me. And then there's the question of endurance. The hearing was months away from the filing. Months of legal preparation, of waiting, of carrying something heavy in private while trying to maintain ordinary life. I kept teaching my seminar. I kept reading the Chronicle in the morning. I kept watching the neighbor's cat on the fence rail, not because I was unaffected, but because I understood that the alternative, to collapse into the crisis and let it define everything, would have been a kind of surrender to exactly the narrative they were trying to write about me. You don't prove your own competence by falling apart under pressure. You prove it by continuing. Lester is still out there. We have not had that dinner yet. I think we will. I think he is a man who made a terrible choice under the influence of someone who was very good at making terrible choices feel reasonable, and I think he will have to live with that knowledge for the rest of his life, which is a harder sentence than anything a court would hand down. I don't carry hatred for him. What I carry is something quieter and more complicated, a love that is still present but no longer unconditional in the way it once was. The mockingbird is back in the pecan tree this spring. Same branch, or close enough. Some things stay,